family member of those of the family of the executed who lives in Norway and who has studied law. He will speak about the rule of law and the Islamic Republic.
خانم‌ها، آقایان.
Ladies and gentlemen, today
راجع به مبانی حقوقی و قانونی
I want to speak to you about the legal foundations, the legal basis of the collective executions in the 1980s and especially 1988.
روشن شدن این موضوع که جمهوری اسلامی
In order to clarify that the Islamic Republic does not even respect its own laws that govern due process and fair trials. What the Constitution requires have not been respected. I have to first to explain, to present brief explanations on the rule of law and the legality of crimes and punishments. The rule of law requires equality before law. Equality means that no one should be distinguished in front of law. Every individual is protected by law, and their social or economic status does not affect their status before law. And independently from color, race, ethnicity, religion, and geographical situation, everyone is equal. The rule of law is a fundamental concept for prevention of arbitrariness and abuse of power, for accountability and control. The rule of law is a fundamental principle for economic development and especially political development. The rule of law is a value beside values such as freedom, justice, and political participation. From this perspective, the rule of law prevents abuse of power. Speaking of rule of law, the three ideas of freedom, human rights, and equality have a special status. And they are critical to its concretization. In the rule of law, the principle of legality of crimes and punishment stands. No one and no action can be considered a crime unless it has been foreseen by the law. Punishment aims at correction and not revenge. Punishment should be proportional to the crime.
اصولاً کلاً قانون اساسی جمهوری اسلامی در کلیتش یک قانون
In general, the Constitution of Islamic Republic is an ideological law, partial and undemocratic.
موجود در میثاق‌های حقوق بین‌الملل سازگاری نداره.
It is not compatible with international human rights standards.
در همون قانون مواردی پیش بینی شده که چنانچه
Still, in the same law,
در کشور
there are rules
برقرار بود و به قوانین
that
اجرا
if the rule of law existed in the country and the laws were really implemented, they could have prevented many crimes. These same incomplete standards of the Islamic Republic Constitution. The Constitution foresees that no one can be arrested unless it is foreseen by law, unless in accordance with law. The presumption of innocence, everyone has right to legal counsel, torture is forbidden. The decisions of the courts should be based on law.
و قوانین کیفری عطف به ماسبق نمیشن.
And criminal laws cannot be applied retroactively. In Article 168 of the Constitution that I will focus on, there is a question of political crimes. It says briefly, with no lengthy developments, that political crimes should be examined by a jury, and the parliament should define the political crime. This article has a major legal problem. When we speak about political crimes, we encourage this idea, we reflect this idea that crimes should be divided in two categories, political and ordinary crimes. This definition is incompatible with modern legal standards and modern definitions of crime.
ابتدا یه تعریفی از جرم بکنیم و بگیم که چرا انطباق نداره این تعریف.
First, I'll try to define what is crime.
یا ترک فعلی که قانون به موجب قانون
every action or mission that the law foresees a punishment for is a crime. So, and no action can be prosecuted without, if it's not on the basis of law. Lawyers define three elements for every crime. The legal element, which means that law should define which action constitutes a jurm. If you have crossed the red light, this is not a crime but a misdemeanor. It's an offense. So clear, concrete examples should be given. Second element is the mens rea, which is the bad faith, that is the intention of committing a crime. The intention of damaging others. Political activists don't have this intention. Mens rea is absent in the case of political activists. They are ready to sacrifice themselves for the interest of people. Third element of crimes is the action, is the material element. You should have committed something so that your action is qualified as a crime. In the absence of this material element, this action, you cannot be punished. The mere intention or idea of committing a crime is not punishable. A clear example we had in Norway.
به مرکز یهودی‌ها تیراندازی کرده بودن، همزمان پلیس تلفن اینا رو کنترل کرده بود و اونجا گفته بودن که میشه خب سفیر آمریکا رو هم به گروگان گرفت و از این
The Jewish center
کردن به تاب تروریسم
was a few people shoot at the Jewish center. These people were arrested because they were carrying weapons illegally and they committed a terrorist act. So they were condemned not because of what they were thinking, but because of the actions they had committed. The definition of political crimes in international law since 1933, when the French president was killed, a few conferences were held, and this was an issue in international legal circles. And the last was the Copenhagen Conference in 1935. The definitions in these conferences are conceptual definitions. They don't contain clear examples.
اقدام علیه امنیت کشور. این چه چیزی هست اقدام علیه امنیت کشور؟
So they define conceptually the notion, but they don't mention the actions that constitute such crime. There is a religious reason that it has been proceeded like this in Iran, because what they call the science of the judge has a great importance in their system. After the Second World War and the massacres that happened, and parallel to the trial of some of the criminals of war, the states sort of creating
میثاق حقوق بشر سازمان ملل متحد. این میثاق
a covenant that ended up in the United Nations Covenant on civil and political rights.
استثمار
This is a very important document about on different topics, slavery, discrimination, women's rights and other issues. With the adoption of this document, all the previous legal standards were nullified. That's why after 1935 this notion of political crimes became caduc and abandoned. So the mere use of the term political crime is incompatible with modern international legal standards and the UN human rights standards.
جمهوری اسلامی هم تعریفی از جرم سیاسی نکرده، فقط تعریف اون
The Constitution of Islamic Republic does not define political crimes and delegates this to the parliament, to the legislator, and states that the criminal crimes should be considered by the juries. None of us lawyers or human rights activists have witnessed such a thing. It has not materialized. In September 2000, the government sent a draft law to the parliament on political crimes, and a group of members of parliament also presented a similar draft law. And then the result of these drafts was presented to the parliament. The first article of that draft law, which is yet to be considered in the parliament, states action or omission, that according to the existing laws are punishable if they are committed with political intentions against the existing political system or government or the political management of the country or the interests of the Islamic Republic or the rights of citizens and public freedoms are committed. This will be a political crime. This is a general definition. It's a conceptual definition. Action against Islamic Republic. What does that mean? Who defines what distinguishes an action against the Islamic Republic from an action that is not such? The judge. Who else?
به مصادیق جرم سیاسی پرداخته نشده. دلیل ایدئولوژیک داره. کسایی هم که خواستن که این
So even in this draft law, there's no mention is made of examples of concrete examples of political crimes. And even these people who had the good intentions and wanted to do something, they were not able to do anything because of ideological reasons. Because in political Islam, the science of law is more important than the law. So when the law decides that I have committed an action against the Islamic Republic, this is enough and it doesn't need to respect any other rules. And that's because of this, because the system is going on in the same way still, and they decide in this way. So there is no law in Iran concerning criminal crimes, political crimes. And those who try to define it, they met significant problems. So all that has been committed against political prisoners have no legal foundations. And the principles in the Islamic Republic on the right to defense and legal counseling, prohibition of torture, presumption of innocence, none of these are credible because these are these are rules of criminal procedure. The crime is not defined. With the order of massacre of political prisoners by Khomeini, this massacre was an example, a clear example of lack of commitment of the authorities of Islamic Republic to their own laws. This is political savagery, a historical hatred of those who think like Sheikh Fazlullah Nouri since the constitutional revolution against progressive forces of the country who wanted to free the society from the dominance of its political Islam and build a society based on rights and rule of law. The 1980s was the decade of massacre, illegal trials, in which political and social activists, women, cultural activists were mistreated, and this was the culmination of the arbitrary actions of prosecutors and revolutionary courts. After 10th of June of 1981, political prisoners were punished without having a right to legal counsel or tried, and this continued until 1988 when it culminated. Some of the prisoners were arrested quite some time ago. They were still, some others were still in their prison terms. I can mention a few. Piruz Ehya, who was imprisoned under the Shah and under the mullahs, and my brother, my own brother, were both arrested in 1986. They were both condemned to imprisonment, and they were executed in 1988. Some of them were going to be released. Some of them were not yet tried. They were expecting trial. What should be done? As a member of the families of those who lost their lives in 1988, and as a lawyer, I believe that the location of burial of those who lost their lives should be identified. Families should have access to their cases. Identification of those who ordered this national tragedy and those who executed the orders, and their trial, and then identification of one day, designation of one day in their name are the minimum we demand. Last thing I wanted to mention is about pardon and forgiveness and remembrance. In trials, the claims that are private can be renounced. Massacres, only private claims can be withdrawn. Massacres are not private issues. This is an affair of social conscience. So no one can withdraw a claim with regard to these actions. Trial of these criminals. These criminals should be judged and to make a document for history and for those who come afterwards. I read something yesterday. I would like to share with you this phrase. Signs. Names are signs that remain in the memory of the society and create the image of a historical event, and they take this image from among many other events